showstopper.
I just want to let you know, because you followed.
Lance, send me afterwards if you give me an update on Maxine.
On Maxine Street?
So we haven't until, we didn't touch that until, because there's so many different things going on, so.
That was taken off the agenda.
Yes, yes, it was. It has been, yes. Yes.
All right, good morning, everybody. The meeting of the Escambia County Planning Board for February 4th, 2025 is hereby called to order with 6 members present. We do have a quorum. It's just a reminder to put your phones on silence or turn them off to not disrupt the meeting. And if you would, please stand and join me in the Pledge of Allegiance. I pledge allegiance Thank you. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll now entertain a motion to waive the reading of the legal advertisement.
So moved.
Second.
We got a motion and a second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. The rezoning meeting minutes from the previous meeting dated January 7th, 2025 have been provided to the board members. Are there any additions, deletions, or corrections? If not, I'll entertain a motion to accept the rezoning meeting minutes into evidence.
Second.
Got a motion and a second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. The rezoning hearing package for February 4th, 2025 with findings of fact have been provided to the board members. I'll entertain a motion to accept the rezoning hearing package with findings of fact and legal advertisement into evidence. Do we have a motion?
So moved.
Motion
Second.
second. All those in favor, please signify by raising your right hand. All those opposed? All right, the rezoning hearing package with findings of fact and legal advertisement will be marked and included in the record for all of today's cases. Will the court reporter please swear in members of the staff?
Raise your right hand, do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, nothing but the truth, and so you do affirm?
All right, the board has previously qualified staff to offer expert testimony in the area of land use and planning. Does anyone have any questions regarding their qualifications and ability to offer expert testimony? All right. At this hearing, the planning board is acting under its authority to hear and make recommendations to the Board of County Commissioners, the BCC, on rezoning applications. These hearings are quasi-judicial in nature, and these hearings are like evidentiary hearings in a court of law, however less formal. All testimony will be given under oath, and anyone testifying before the planning board may be subject to cross-examination. All documents and exhibits that the planning board considers today will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the planning board will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Each individual who wishes to address the planning board must complete a speaker request form and submit it to the planning board clerk. These forms are on the table in the back of the room. You will not be allowed to speak until we receive a completed form. And please note that only those individuals who are present and give testimony on the record at this hearing before the planning board will be allowed to speak at the Board of County Commissioners meeting. No new evidence can be presented at the BCC, therefore all testimony and evidence must be presented here today. The planning board will provide a recommendation for each rezoning request to the BCC, which will review the testimony, documents, and exhibits, consider the closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of the decision of the BCC must do so in a court of competent jurisdiction within 30 days of the date the BCC approves or rejects the recommended order of the planning board. All written or oral communication outside of this hearing with members of the planning board regarding matters under consideration today are considered ex parte communication. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in the BCC Resolution number 96-13. As each case is heard, I will ask that any board member who has been involved in any ex parte communication to please identify themselves and describe the communication. As required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following approval conditions. The applicant has the burden of presenting competent substantial evidence to the reviewing board establishing that the requested zoning district would contribute to or result in a logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area required for mailed notification. A logical and orderly pattern shall require demonstration of each of the following conditions. A, the proposed zoning is consistent with the future land use FLU category as prescribed in LDC Chapter 3 and with all other goals, objectives, and policies of the proposed FLU amendment transmitted for state agency review. The proposed zoning is consistent with proposed FLU and conditional to its adoption. B, the proposed zoning is consistent with the purpose and intent and with any other zoning establishment provisions prescribed by the proposed district in Chapter 3. C, all of the permitted uses of the proposed zoning, not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with the surrounding uses. These uses of any surrounding undeveloped land shall be considered the permitted uses of the district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities protected by fair housing laws. Appropriate is spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6. The isolated district would nevertheless be transitional in character between the adjoining districts, or the differences between those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balancing of interest between the isolated district and the adjoining lands. And E, if the land uses or development conditions within the area surrounding the property of rezoning have changed, the changes are to such a degree and character that it is in the public interest to allow new uses, densities, or intensities in the area through rezoning. And the permitted uses of proposed district are appropriate and not premature for the area or likely to create or contribute to sprawl. At the beginning of each case, as long as there are no objections from the applicant, we will allow staff to briefly present the location and zoning map and photos of the property. Next, we'll hear from the applicant and any witnesses they may wish to call. Then we will hear from staff and any witnesses they may wish to call. And finally, we'll hear from members of the public who have filled out a speaker request form. Today, there's one case to be heard. The rezoning application for consideration is case number Z-2024-20, which requests rezoning of 810 Neal Road from low-density residential district, 4 dwelling units per acre to LDMU, low-density mixed-use, 7 dwelling units per acre, as requested by Meredith Bush, agent for 29 and Neal Development LLC, the owner. Members of the board, have there been any ex parte communication between you, the applicant, of the applicant's agents, attorneys, or witnesses with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? Please also disclose if you are a relative or business associate of the applicant or the applicant's agent.
No,
Kevin?
no.
Not all.
No to all?
No to all.
Not all.
No to all.
All right, great. Mr. Adams, thanks for joining us, and happy birthday.
Oh, well, thank you.
So, there you go. Is this where you wanted to be? Staff was notice of the hearing sent to all interested parties,
Yes, sir.
and was notice of the hearing posted on the subject property.
Yes, sir.
Great. Meredith, are you okay with photographs going first? All right. Staff will now present maps and photographs for case Z 2024-20.
Good morning. Allison Lindsay, Urban Planner Development Services. Before I show the maps, I do want to note that this case went to the Board of County Commissioners on December 12th, and their recommendation was to remand it back to you, the Planning Board, so you can assess the request for low-density mixed use. So this is the location map showing the location on Neal Road. This is the zoning map showing the current zoning of LDR. This is the future land use with the mixed-use suburban. And this is the existing land use of the properties around the subject parcel. And this is an aerial photo of the property. And this is the public notice that was posted along Neal Road. This is looking west along Neal Road, looking east along Neal. This is looking north onto the subject property. This is looking south across Neal Road. And that's the maps and photography.
Great, thank you. Meredith, you'll please come forward. And then just state your name and address for the record.
Yes, good morning, Board. Meredith Bush, 125 East Intendencia, Pensacola, Florida, 32502.
And then you did receive a copy of the rezoning hearing package and findings of fact.
Correct.
All right, and I understand you've got the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code.
Yes.
All right, good to go.
Yes, as was mentioned by Ms. Lindsay, this case, you may recall, was before you a few months back. We came in initially seeking a commercial designation on the parcel, went to the Board of County Commissioners, had discussion there. They felt low-density mixed use would be more appropriate, so we're back before you today with a request for LDMU. Going through the criteria, A, consistent with the comprehensive plan. The proposed amendment is consistent with the intent and purpose of the current future land use of mixed-use suburban. B, consistent with the zoning district provisions. The proposed amendment to LDMU is consistent with the intent and purpose of the Land Development Code. The low-density mixed-use district establishes appropriate areas and land use regulations for a complementary mix of low-density residential uses and compatible non-residential uses. The primary intent of the district is to provide for a mix of neighborhood-scale retail sales, services, and professional offices with greater dwelling unit density and diversity than the low-density residential district. As to criteria C, compatible with surroundings. The proposed amendment is compatible with surrounding existing uses in the area. Within a 1,500-foot radius, the applicant has identified property zoned LDR, LDMU, and HCLI. To ensure additional compatibility with existing adjacent uses, if the amendment is approved, further review and evaluation through the Development Review Committee process may be necessary. Criteria D, appropriate if spot zoning. The amendment request, if granted, would create spot zoning. Despite being a case of spot zoning, the proposed LDMU designation demonstrates a strategic and coherent approach to development. The introduction of new LDMU zoning in this area would establish a distinct zoning district that differs from the surrounding LDR and HCLI. However, the spot zoning is appropriate because it functions as a critical transitional buffer between these two contrasting land uses. By placing LDMU zoning between the LDR and HCLI zones, it helps to mitigate the potential negative impacts of activities on the HCLI parcel with the adjacent residential neighborhoods. The LDMU zone provides a gradual shift in land use intensity, reducing conflicts such as noise, traffic, and visual disturbances, while offering nearby residents convenient access to services and amenities. This transition enhances the overall compatibility of the area and promotes a more harmonious development pattern. The zoning adjustment also maximizes the potential for economic growth in the region. And then as to criterion E, appropriate with changed or changing conditions. Based on the existing uses and intensities and zoning district allowances, the proposed amendment would not create urban sprawl and would be compatible with existing development. It is in the public interest to allow the LDMU zoning. The proposed rezoning will contribute to a logical and orderly development pattern. We've also submitted the required compatibility analysis for locational criteria. I have reviewed staff's findings and believe they are supportive of the request, and I'm happy to answer any questions.
All right, board, are there any questions for Meredith at this time? All right, if there are, we'll bring you back up here. All right, staff will have you go through your presentation at this time.
Okay. So on criteria 1, consistent with the comp plan, the proposed amendment to low-density mixed use, it is consistent with the future land use of mixed-use suburban. The rezoning request to low-density mixed use would accomplish the directives by creating the possibility for retail sales and services that would provide daily necessities to residents within a short walk or drive. The development plan is supported in the future land use 1.5.1, which was created to encourage redevelopment in underutilized properties and to maximize development densities and intensities. Criteria B, consistent with the Land Development Code. Section 3-1.6B of the Land Development Code states that such criteria are created to allow for residential and non-residential uses and to be located in close proximity to one another. Other items of compatibility may be required, such as landscaping, buffering, screening to protect the lower intense uses. LDMU district would allow areas and regulations for general commercial activities, especially the retailing of commodities and services under 6,000 square feet. Changing the zoning from LDR to LDMU would allow for a mix of residential and non-residential operations along Highway 29 that could benefit the residents in the area and reduce the vehicular traffic and congestion within a walkable or short driving distance. Criteria C, compatible with surrounding uses. The proposed amendment would be compatible with the surrounding existing uses in the area. The majority of the surrounding land uses are low-density residential and heavy commercial light industrial. The requested low-density mixed-use district is appropriate for neighborhood activities such as retail sales and services, requiring all to be in the confines of a building. The proposed request to LDMU would be a transition between the LDR and the HCLI, resulting in long-term compatibility with the existing residential uses without any conflict. Criteria D, spot zoning. It was determined that the proposed LDMU would establish or reinforce spot zoning, as there are no other properties zoned LDMU. However, spot zoning is not prohibited, while allowing more non-residential uses in the area of the nearby residential. The intersection of Neal Road and Highway 29 is an appropriate location for more intense uses such as neighborhood development that will service the adjacent residential neighborhood, allowing cohesiveness between residential and commercial aspects of the area. Criteria E, appropriate with change or change conditions. The land uses or development conditions within the subject area surrounding the property, they are changing. There is a new subdivision, enclave at Bellaterra, located on the adjacent parcel to the north. The subject parcel is joined with the HCLI property located along Highway 29, making it a corner lot. The area along Neal Road has single-family lots. The request to LDMU and the potential uses would be compatible with the existing surrounding residential development patterns. And also, since this was combined with the parcel on 29, it is still a split zone parcel. You would have the LDMU if approved, and then the HCLI. And that's the staff's findings.
All right, thank you. Board members, are there any questions for staff? All right, seeing none. This time, we will go to members of the public that wish to speak. Remember, if you want to speak before the Board of County Commissioners on this item at their next meeting, you will need to speak here today. I've got two individuals signed up, and we'll start with Ms. Sharon Colburn. If you'll please come forward and state your name and address for the record and be sworn in.
Hi, I'm Sharon Colburn, 1100 Ridgeway in Cantonment.
Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. All right, so I had pulled up the low-density mixed-use requirements, and I wanted to kind of go over some of that. It says here that it should be a complementary mix of low-density residential uses and compatible non-residential uses within a mostly suburban area. If you're familiar with that area is not suburban. It is rural. It's a rural area. When you saw the pictures, all you saw were trees. The lot sizes in the neighborhood I live in are between 2 and 3 acres. It is a small 2-lane country road, beautiful trees. It's a rural area. It also says it's intended to rely on a pattern of well-connected streets and provide for the separation of suburban uses from more dense and intense urban uses. There's one street, it's a dead end. It's Neal Road, and it dead ends into our neighborhood. It is not connected to anything. It is by itself. It is a small country lane road. Also, it talks about separation from more dense to intense urban areas. There is nothing. If you are on the west side, I'll say this again, if you're looking at the west side of 29 from the paper mill, there are no commercial properties. I sat here at a meeting when we were considering another property talking about improving infrastructure, and I can't remember what gentleman said this to me. We talked about kind of like it's a chicken and egg kind of thing, that we can't really improve the infrastructure until there's a reason to. And so with all of the approving of the neighborhoods, it would have to wait. Well, there's no commercial around here. Okay, is this a chicken and egg kind of thing too, is what I'm thinking, because there's nothing there. There's no commercial properties from Muskogee Road all the way. I know that at the board meeting, Mr. Berry was very, he thinks that this is a great idea in his opinion, although he does not live on this street. What concerns me the most is what can happen in this LDMU. Medical marijuana dispensing facilities, sales of beer and wine, tattoo parlors, restaurants. There's also uses, conditional uses that can be approved. Nursing homes, assisted living facilities, dormitories and residential facilities, substance abuse treatment and post-incarceration reentry, manufactured homes, liquor sales, telecommunications towers of any height, self-storage facilities. All of those things could happen.
I'll let you wrap up if you got another
I
10,
mean, I would
15
like to,
seconds.
I mean, I have more I'd like to say, but.
If you can make it quick, that'll be all right.
All right, so a lot of the things it says, along an arterial or collector street, no. 2-lane, little country road that connects to nothing. That's number 1, proximity to an intersection. Number 2, proximity to traffic generator. Infill development, an area where already established non-residential uses are consistent. No, there's nothing.
All right, thank you.
Yeah.
Thank you very much. All right, Ms. Jacqueline Rogers, if you'll please come forward, state your name and address for the record, and be sworn in.
My name is Jacqueline Rogers, 1420 Ridgeway.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Okay, thank you for changing the notification to put the board action on here, but you didn't do that when you read it today. And your handout today doesn't talk about board action. So you can deny this if this upzoning would be worse and have adverse impacts for the community. So I just want to remind you of that. But I do appreciate you put that on the mail out. This is very slim analysis on here. It doesn't talk anything about water capacity or anything like that. They're using old maps and aerials. It's no longer vacant next to it. It is a big subdivision that you guys approved when you let it opt out of the subdivision. So there's low density residential, and they've already built a house right up to this lot. This is not a built area. The staff and the applicant are using FLU 1.51 to maximize development and densities in a built area. But like she said, this is a rural area. The things that are allowed here, sales of beer and wine, medical marijuana dispensaries, and if there's a neighborhood retail, it could go up to 35,000 square feet. That's what you're permitting here. And then with conditional uses, there's even worse things. They keep saying they've combined the lot, so why didn't they bring proof today that the lot is combined? They keep saying, and the staff says they're going to. We've been to how many in the meetings? But then they say, oh, it's on Highway 29 because they're going to combine it, or they did combine it, but there's no proof, and you can only consider the proof that's in the record. They had plenty of time. When I read through the application for the applicant, there's talk about commercial, rezoning to commercial. So there's a lot of mistakes even in the application itself. But they say this is going to be a transition. If they truly did combine this lot, it can't be a transition because they're going to put one development on that lot. They wouldn't be combining the lot unless they wanted to put one development, so it cannot serve as a transition. Like Sharon said, there's no traffic interconnected streets. It is spot zoning. The industrial uses that she's saying that you're buffering against are not even allowed in mixed-use suburban with HCLI zoning. So you don't need a buffer there for that, and you can't buffer. It's going to be on the same lot. The only other LDMU that is located around there is on Highway 29. So there's no other commercial there. The HCLI that they're talking about, look at the existing uses in your packet. Look at the pictures. They're single-family homes. Just because the county came and dropped HCLI on there, they're single-family large lot homes. Rezoning to LDMU is suitable for developed networks is what it says, and this does not have that. It doesn't meet any of the location criteria like Sharon just went over. There's none of the location criteria that they are meeting. 7 dwelling units per acre when we have large lot subdivisions right next to it. There's no proximity to any type of arterial or collector streets is what they're calling it, and I will. Yeah, in the findings, the staff says the intersection of Neal Road and Highway 29, this is not at the intersection of that. It's an interior lot and there's homes right across the street. So while LDMU is better than commercial, it still allows, multifamily dwellings up to 35,000 square feet of residential. So for those same reasons that you denied it before, I would ask that you would consider denying it again. Thank you.
Thank you. All right. Were there any questions for either of the speakers or no? All right. Okay. Did you have any questions at this time for staff or the applicant themselves?
I do have one. I know we had this discussion a few months ago. So is this still 2 independent lots, or was this combined?
It's been
It has been combined, okay.
It has been combined through the property appraiser's office. The maps have not yet been updated. So, and contrary to what was just stated, testimony is evidence, and so I'm letting you know, it's been combined.
I wasn't here for the previous meeting, but since they have been combined, it's now, the larger parcel that's on 29 is HCLI, correct?
Correct.
Historically, if you combine two lots, what happens to the lower zoning? Is it, I'd like to hear from staff.
In this case, that would not apply.
Okay,
That would not apply in this case at all
Okay.
due to the size of the larger piece. So that would not apply. I know there's a provision that does allow for that, but in this case, I want to be clear for the record because there's lots of misinformation out there. In this case, that would not apply. This LDMU, which was a recommendation, a directive from the Board of County Commissioners to come back to make consideration for this. LDMU is an appropriate zoning in section 3-2.6F of the Land Development Code. It says this specifically. It says, I want to state it for the record because there's lots of misinformation that's not accurate. It states, the district is appropriate, LDMU is appropriate to provide, as stated by both parties, to provide transitions between areas zoned or used for low and medium density. This district got a low DR, it's LDR, so the Land Development Code supports this zoning category for when you want to have neighborhood type of commercial type uses. That's fronting a major arterial road where you have those services that can come in. And also to Mr. Owens, I want to say this for the record. This zoning category, it has certain restrictions and certain protocols in place. So that if anyone go beyond a certain size, that project must go before the Board of Adjustments. In that process, they must present the size, the scope, and the use. Because there's a certain criterion that's associated with this low density mixed use, because these type of areas, they do need low impact neighborhood type uses. It was stated that this area is not mixed use suburban. This area is, according to the official land use map. And if you read the definition for mixed use suburban, we can read that. It says an area of low, predominantly residential type uses. That comes from, if you want to state it for the record, that's the definition. So it states that. So I just want to get the correct information out there so you can have and make the choice based upon accurate information.
okay, thank you. Thank you.
Mr. Chair?
Yes.
Yeah, so what would be the total capacity for residential units on that property?
So.
Or is it
well,
tied in with the other property, or it's up to 29?
Well, the density on the piece that is LDMU is 7 per acre. On HCLI, it's 25? 25 per acre.
Commercial?
They'll never get that there.
The other, on 29, it's commercial?
It's heavy commercial, light industrial. The piece, and the reason it can't, that HCLI can't simply apply to the whole parcel is because, as Mr. Jones was stating, the aggregate is greater than 10 acres.
Yes.
And so that provision, otherwise we could just take the HCLI and make the whole thing HCLI without ever coming before you.
And we did look at that option, but the code does not support that split zoning. So if it is on LDMU, the requirements of the LDMU, the density, all the safeguards must be in place and must remain in place.
And just in response to some of the concerns about the size of Neal Road, although not within your purview, it's a development review committee issue. Access would be off 29.
So that was going to be my kind of question, was both speakers talked about location criteria not meeting because it is a smaller road and not a collector. So is that the only reason why we can agree that the location criteria is acceptable, because it's going to have access from 29? Can y'all explain that a little bit?
I would not say that's the only reason. So you only have to meet one of those location criteria that she listed, one of which is a compatibility analysis, which we've submitted as part of part of our packet. So even not considering whether or not it's on an arterial or collector, just based on the strict compatibility of the uses, we would submit that we've met locational criteria.
So it's an or, not an and.
Correct.
Thank you.
Yes, and to support that, based upon the code, gotta have accurate information. It says at least one of the following. And because it has been supported, it has been presented, the property is combined. But again, Chris Jones don't update their maps as quickly as we would like them to do. That's their process. Thank you. Thank you.
Yeah, our friend Bubba Peters would like you to
Yes,
go
thank
ahead and
you.
update that.
And I know Bubba Peters very
I know.
well. I just gotta get used to that. No disrespect. Yes, so at least, the code says at least one, and all of that will be looked at wholeheartedly. Because we do know this area very well. We are aware of the neighborhood concerns, so we would definitely not take this decision lightly at all.
Any further questions?
I just would like to say to this board, one of the speakers said there's not a lot of commercial, but if you look at this image Allison's got pulled up here, there's a lot of commercial on 29, so, you know, that's
A lot of commercial opportunities.
definitely.
Yeah.
So just consider that, it's gonna be bordering that, the potential is there.
Yes.
All right. There's nothing further. I'll entertain a motion one way or the other from somebody.
I'll make the motion to approve Z 2024-20 as presented.
Okay, we got a motion on the table. Is there a second?
Second.
Got a second? Any discussion? Okay, all those in favor of the motion, please signify by raising your right hand. All those opposed? Okay, motion carries. That is the only case we had today for rezoning, and we will move on over to the regular planning board meeting. So I'll adjourn that meeting, and now this meeting of the Escambia County Planning Board for February 4th, 2025 is hereby called to order with 7 members present. We do have a quorum. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement. Do I have a motion?
So moved.
Motion second. All those in favor, please signify by raising your right hand. All those opposed? The planning board meeting minutes for January 7th have been provided to the board members. I'll entertain a motion to accept the planning board meeting minutes into evidence. Do I have a motion?
So moved.
Second.
Got a motion and a second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. The planning board hearing package for February 4th, 2025 has been provided to the board members. I'll entertain a motion to accept the planning board hearing package and legal advertisement into evidence. Do we have a motion?
So moved.
Second.
All right, all those in favor, please signify by raising your right hand. All those opposed? Great. All right, we do have a public hearing today. This is an opt-out application for consideration in case number OSP 2025-01. Request removing the 2300 North Highway 29 block from the Midwest Sector Plan Regional Employment and Wetlands Jacks Branch and assigning the future land use category RC Rural Community as requested by Meredith Bush, agent for David Fitzpatrick and Diane Fitzpatrick, the owners. We want to start with any aerials or photos that we have, or do we have that for this case? Okay, is that okay?
Morning, Board. Caleb McCarty, AICP Certified Planner for the county. Yes, this request is to remove a parcel from the Midwest Sector Plan, Jacks Branch DSAP, Detailed Specific Area Plan, and it's located on North Highway 29. This shows the location of the property. This is near the Central Commerce Park, as you see Success and Power Boulevard. This parcel was not included in the plating of that and essentially is a part of the sector plan that wishes to be removed. This shows the zoning map of the property. The request would be rural mixed use, RMU. The 2020 future land use map, AA15. And then our 2030 future land use map showing the regional employment and the wetland as indicated by the DSAP. This is the proposed future land use, their rural community future land use designation. Let's request it. And then our DSAP map again that gives us overall of the area. This is in Jack's Branch, Sector 48. That shows that this is indeed part of the Commerce Park. There is some flood zone that runs across the property. This is our development program acreage map. The property is 2.4 acres of the totality of JB 48, 80 acres. This is the aerial. It's currently vacant along 29. This is our notice of public hearing sign that we placed on the property along 29. This is looking west onto the site. It's heavily wooded at this time. This is looking onto the site again from 29. Looking north along 29 towards Success. Looking east across Highway 29 here. And this is looking south along 29 toward Power Boulevard. That concludes our photos and maps for this case.
All right, thank you. Meredith, would you like to come forward and walk us through the applicant's case on this?
Yes, thank you. Meredith Bush, attorney at Clark Partington, 125 East Intendencia, Pensacola, Florida, 32502. I will walk you through the opt-out criteria. I have reviewed staff's findings, and staff does support our request. First criteria is wellheads. Based on the county GIS system, the subject property is not located in a wellhead protection area. Any historical sites. A copy of the Division of Historical Resources TRS site file review correspondence has been submitted. There were no historical resources detected on the subject property. A cultural resources map and survey roster was also submitted. As far as natural resources, the property is located within the Jacks Branch drainage basin. Although part of it is designated wetlands and there is flood zone indicated, if you look at the county GIS wetlands map, there are no wetlands indicated. The property is located within the flood zone X and flood zone A. The soils indicated on site include Troop Porch and Pelham loamy sand. The proposed request is consistent with the comprehensive plan. There's infrastructure in place to support any allowable development. Consistency with key components in the comprehensive plan include traffic. The subject property is located west of Highway 29 North. FDOT provides an annual average daily traffic count along this portion of Highway 29 of 25,000 trips. All area roadways have capacity to support the requested change in future land use category. As to sanitary sewer and water, Cottage Hill Water Works is the area water provider. The proposed amendment is not expected to create capacity problems for Cottage Hill Water Works. Once a project is proposed and application submitted to the county, such proposal shall identify any other providers and determine whether septic tank service or available sewer connection will be utilized. Any proposed development would receive approval through the site plan review process. ECUA will provide sanitary sewer if applicable. The proposed amendment is not expected to create capacity problems for ECUA. Wetlands and drainage, any necessary stormwater management will be provided.
Gentlemen. Sorry. Thanks, Horace.
Will be provided in accordance with the Escambia County and Northwest Florida Water Management District regulations. The stormwater system would be designed for a 100-year storm event. Solid waste will be collected by ECUA for disposal in Escambia County landfill, which has adequate existing and projected capacity. Schools, the current school assignments for this location for the 2024-2025 school year are Jim Allen Elementary, Ransom Middle, and Tate High. Any proposed development will adhere to the site plan review process. Again, there were no historical structures on the sites. Our submission includes a list of 45 comprehensive plan policies and land development code provisions, which we have met. Next, the opt-out requires that we look at the parcel size and aggregate of other opt-outs. The subject property is 2.38 acres. This represents 0.292% of the existing development acreage of 8,168.22 acres described in the sector plan. The total acreage of the Jacks Branch DSAP designated regional employment is 283.2 acres. Withdrawal of the applicant's acreage will result in a 0.8427% decrease in developable acreage. At the time of the application, the total acreage opted out of the sector plan is 477.99 acres. Transportation infrastructure, again, is located on 29 with an average daily traffic count of 25,000 trips. There is existing capacity. The underlying zoning is rural mixed use, which is compatible with the requested FLU category of RC. The requested FLU category of RC will be consistent with the underlying zoning uses, densities, and intensities. The prior future land use designation of this parcel was rural community. And as to lost development rights, prior to the adoption of the Midwest Sector Plan, the parcel was zoned VR2. VR2 had a gross density of 1 unit per 0.75 acres. Regional employment is primarily for office, distribution, and industrial uses. Commercial and residential uses may also be permitted in regional employment. However, there were no density requirements included in the DSAP. We feel we've met all the criteria and would ask that you recommend approval of the opt-out. I'm happy to take any questions.
Any questions for the applicant? All right, staff?
Yes, thank you. As confirmed, we did find that it met all the criteria, and I will provide a brief analysis for this. Again, we confirmed that this is removal of a 2.51 acre parcel from the Jacks Branch DSAP. This property is located along 29. The applicant is requesting to assign a future land use of rural community. The underlying zoning of the parcel is rural mixed use, which allows 2 dwelling units an acre. Concerning the analysis of available facilities and services for sanitary sewer services, the utilities will be reviewed by ECUA Engineering. ECUA service lines are indicated along 29 and within the Central Commerce Park, as indicated in the DSAP wastewater plan. Once a project is proposed and the application is submitted to county, the proposals will be evaluated through the site plan review process in conjunction with ECUA review for sanitary sewer. For solid waste disposal, we found that Escambia County continues to maintain its adopted solid waste levels of service commitments. Solid waste service is 6 pounds per capita per day. According to the application, solid waste will be collected by ECUA for disposal at the county landfill. Concerning potable water service, we found that potable water for this area is supplied by Cottage Hill Water Works. A conceptual potable water distribution system was developed based on this analysis and is available in the DSAP. Cottage Hill Water Works potable water system was found to meet the capacity for the final build-out as calculated by the DSAP impact indicated. Funding for any expansion or improvements to the potable water distribution and water treatment systems within the service area is generated by the respective utility authority. Stormwater management, we found that the amendment request to opt out will not rely on stormwater requirements or calculations. However, all developments are required to meet or exceed the standards by the Northwest Florida Water Management District and the Land Development Code. The applicant has acknowledged the requirements for stormwater management, and as stated, the stormwater system will be designed for a 100-year storm event. Compliance with these stormwater management provisions and these policies will be reviewed and confirmed at site development plan approval process, regardless of the proposed future land use change or use. Concerning traffic, streets, and access, based on section 4.02 in the public facilities plan and the sector plan, A transportation analysis were conducted on different roadways and segments that evaluate the existing facilities and travel characteristics, as well as the potential impacts and road capacity needs for the 5-year interim period and the build-out of the plan. The county's Traffic Transportation Department has provided comment, and they have no traffic capacity concerns related to the request. Any development, again, commercial or residential, requires submittal review and approval through the site plan process, meeting all the requirements of the LDC and the comprehensive plan. US 29 is a state roadway, and any proposed connection would need to be reviewed by FDOT. Concerning recreation and open space, our analysis found that the intent of open space is to serve as a buffer to protect and preserve areas of significant natural resource and wildlife habitat, while offering passive recreational opportunities. The rural community future land use category intends to recognize existing residential development and neighborhood serving non-residential activity while supporting new development through compact development pattern that serves the rural and agriculture areas of the county. The county does not have a level of service standards for recreation. However, any development could create usable, accessible open space that would contribute to the overall interconnectivity of the development. The amendment will not rely on open space requirements. However, any development must be reviewed through the site plan development review process. Concerning public school facilities, we found that based on the public records of the county, the assigned schools are Jim Allen, Ransom Middle, and Tate High. The school district provided courtesy review, which demonstrates capacity will not exceed the calculations for residential development on the 2.5 acres. Once plans are submitted, this will be reviewed, and if the need arises, there may be adjustments to the school boundaries to balance capacity among the school. Concerning impact on natural resources for wellheads, we found that based on GIS county systems, the subject property is not located in a wellhead protection area. All right. Concerning historically significant sites, we found that the applicant did provide documentation stating there are no previously recorded historical resources within the parcel. We did have a copy of the Division of Historic Resources TRS site file review correspondence that was included in this opt-out request. And according to the correspondence, a cultural recess assessment survey of the resurfacing of State Road 95 US 29 from County Road 184 to Fletcher Creek was published by the FDOT. The county's comprehensive plan has a section of historic preservation at any time during development. If artifacts are discovered, they are to cease construction under that policy. Concerning the natural environment, we found that as stated in the sector plan, natural resources, the DSAP contains significant wetlands as regulated by the state, federal, and local governments. And the final design was to avoid and minimize wetland impacts to the greatest extent possible. The wetlands in the DSAP are regulated by the state, federal, and local government, and according to the approximate wetland map in the DSAP, approximate wetlands are shown on the subject property. Further evaluation will be required of the site plan review process to determine the extent of any environmentally sensitive areas. Proposals that anticipate any impacts to these areas will require appropriate federal, state, and local authorizations. Also, as stated in the sector plan document, Natural Resources, the DSAP contains significant wetland systems that are listed as regionally significant natural resources by the Emerald Coast Regional Planning Council, and the final design was to avoid and minimize wetland impacts to the greatest extent possible. According to county GIS maps, there are hydric soils on the northwestern portion of the property, and further evaluation will be required at the site plan review process. Tree protection and mitigation will be required also during the site plan review process. As for our comprehensive plan requirements for changes in the existing DSAP, our evaluation and analysis of impact show that components of the DSAP include aspects such as community design, environmental analysis, transportation guidance, and economic development principles. The final land use map, attachment A, identifies the overall boundaries of the sector plan, the distribution, extent, and location of land uses. The land use plan and development program provides specific growth data with development program calculations and assigns permissible densities and intensities for the various uses. The type of development, land use plan, and corresponding densities were assigned based on their appropriate share of the overall sector plan. The total developable area under Muskogee DSAP, located in the southern section of the sector plan, is approximately 3,380 acres. Under Jack's Branch DSAP, located in the northern portion of the sector plan, the total development land is 5,231 acres and is identified in attachment A as well. This parcel is on the east side of North Highway 29 in the regional employment and wetlands of the Jacks Branch DSAP. If approved, the requested removal of the parcel from the sector plan will not create a fragmented DSAP in the JB 48 section. Concerning the parcel size in relation to the individual DSAP land use category and in relation to the overall sector plan and the aggregate acreage of the granted opt-outs, the applicant's parcel is approximately 2.51 acres and is in the Jacks Branch DSAP and is specifically identified in the land use map. Based on staff's calculation, utilizing data from section 2.02 of the DSAP document, the total developable acreage in the entire sector plan is 8,611.8 acres. The applicant's parcel represents 0.029% of that existing developable acreage. Under section 2.02 development program calculation tables, the total residential development acreage of the Jacks Branch DSAP under the regional employment district use is 283.2 developable acres. Removal of the applicant's 2.51 acres will result in a decrease of 0.89% of available residential developable areas in the Jack Branch Regional Employment District. Jack Branch, section 48, the applicant parcel has 2.51 acres, which represents 3.12% of the total developable acres of this section. Removal of the applicant's 2.5 acres that are in section JB 48 from the total developable acreage will result in a reduction of 2.52 total dwelling units under the high density allocation of that area. This is the 15th opt-out requesting submitted to the county and processed by the county. If approved, the total sector plan acreage will be 475.78. The original sector plan profile then identified 15,000 acres of land, the availability of infrastructure and public services, and the protection of natural resources. The calculation used to complete the maximum development scenario of the plan were specific and resulted in a balanced jobs to housing ratio. Changes to or variations of any of the original data used for the plan could hinder the balance and viability of attaining the sector plan goals and objectives. Assuming a maximum theoretical build-out under the mixture of uses, the DSAP area would produce approximately 27,145 jobs. When analyzed using the maximum residential build-out of 23,000 dwelling units, the results to job ratio is that 1.18. It should be considered that although there is no single perfect ratio, an area is generally considered to be balanced if it has a jobs to house ratio of 0.8 to 1.12. If the proposed amendment is approved, the resulting job to housing ratio will be 1.26. To maintain cohesive of the sector plan while at the same time fostering innovative planning and development strategies, county staff will continue to assess each request within the sector plan on a case-by-case basis, providing continuous analysis of the impact of each proposal. The existing transportation infrastructure and any effect the proposal may have on the capacity of that infrastructure. Our Traffic and Transportation Office has no concerns regarding capacity at this location. Concerning the underlying zoning district and the compatibility with the surrounding DSAP land use designation, the existing parcel is currently zoned rural mixed use. The surrounding parcels are zoned rural mixed use and heavy commercial light industrial. If this property is removed from the sector plan, the following range of permitted uses are allowed under the existing zoning district. And we provide the allowed and permissible uses of the rural mixed use, which is again, mixed use, small scale retail sales and services typically are found in the rural mixed use, along with low density residential uses. Continuing on, concerning the consistency of any requested future land use designation within the underlying zoning, the requested rural community future land use category will be consistent with the underlying zoning uses and densities allowed in the rural mixed use. The rural community future land use is intended to recognize existing residential development and neighborhood serving non-residential activity while supporting new development through a compact development pattern that serves the rural and agriculture areas of Escambia County. Concerning the previous future land use designation, again, as shown on our maps, the 2020 future land use was AA15. And concerning the analysis to consider whether the applicant lost development rights or was effectively downzoned as part of the sector plan, this parcel was VR2, like the applicant stated, and was intended as a single-family residential district characterized by rural land development patterns and rural community. Non-residential uses were allowed. With the adoption of the DSAP and the assignment of the regional employment district, the development rights of the parcel will decrease, allowing one dwelling unit per acre with a total maximum allowed residential development of 10% of the northern regional employment district. If approved, any development will need to be evaluated by the Development Review Committee, utilizing current zoning regulations while addressing and minimizing any impacts a proposed development could have on the characteristics of the existing residential development in the area. If approved, the sector plan boundary map will be adjusted accordingly to reflect the removal of the parcel from the plan, and we provide that in attachment B. And if approved, the parcel will be assigned a future land use of rural community as requested, and that is provided in attachment C. That completes staff's findings and analysis for this case.
Thank you. Board, any questions for staff? All right, we do have 2 speakers signed up. Jacqueline Rogers, if you come forward, state your name and address for the record and be sworn in. I mean, you don't have to be sworn in this go around. I apologize.
I still promise to tell the truth.
Great.
If you could just pull up that map that has the land uses with the DSAP. That, I guess right there, that's fine. No, it was that shows the parcel. Just leave it right there, that's good. I mean, you can use your imagination. I've said this before, when is a long-range plan that we've spent over $1 million not just worth less than the piece of paper? And that's what we're doing in Escambia County. Look how ridiculous this is. I live right up there. This is a commerce park, and this was planned, and now we're going to take a piece out of the commerce park because they had decreased development rights. How is that decreased development rights? They could put one house per 75 acres when the sector plan was put on. Now they can put industrial and commercial. You can't put the density of housing, but it's not decreased development rights. There's things that can be put on there. I don't have a lot of skin in the game here, but it's just ridiculous what we're doing. You have a master plan that you're doing at the planning level. You guys are the planning board. Supposedly this is development service that cares about planning. And you make something, you approved it. Look at on the staff on page 7 of the staff under natural environment. They did no analysis on the natural environment. They said there's hydric soils that indicate wetlands. So we will look at further evaluation will be required at the site plan review phase. So basically they admitted to doing no data and analysis as whether this would be appropriate to put housing there. They just avoid it. They say Cottage Hill, but they don't have any letter of capacity. This is a comprehensive plan, future land use change. You're continually going out of balance with the jobs to housing ratio. But then the last thing, yeah, the decreased one, that one just really killed me. So development rights for the parcel were decreased. Well, I guess only if you're a home builder, and that's who we're catering to. So why are we doing this? We either need to remove the plan, or was it a bait and switch to get all those high developments in there? Right north of this, Mr. Hemmer has a big development that used to be rural development. So the county lied and said we were going to have all these planning. He even says in the natural, I mean, he quotes the DSAP language for natural environment. I'm just going to end here where he says, the DSAP contains significant wetland systems that are listed as regionally significant natural resources by the Emerald Coast Regional Planning Council. Do you know how many meetings they had, citizen input they had? And the final design was to avoid and minimize wetland impacts to the greatest extent. And then it goes on to say there's hydric soils. You guys are undoing all the planning with no data and analysis. Again, this is not something that's going to cause me a lot of heartburn, but at some point, when do you really become the planning board? We need you, citizens need you, to become the planning board and to require. I miss the other D1 representative. Welcome to Mr. Owens. I'm sure he'll do a great job too. When he required the staff, he asked the staff, he never required it, to provide the data and analysis and the whole picture. And you guys just aren't getting that. Thank you.
Thank you. Any questions for the speaker?
I mean, I'd like to make a comment. Can I make a comment? First of all, that was pretty, kind of an attack to us. We have, unless I miss them, we haven't done anything yet. We're just listening to an opt-out. application. So we hope through the process that we will make the right decision.
All right, next we've got, I think this says, is it Tony or Troy Tisner?
I think they left.
He left,
I believe he
okay.
left, yes.
All right. All right, is there any discussion on this opt-out case?
Board, I just would like to point out that this piece of property wasn't actually included with the Central Commerce Park.
Absolutely.
It was not included, excuse me, with the plat, losing my voice. It wasn't included with the plat for the Central Commerce Park. That's why we're here, because the applicant attempted to want to develop the property, but realized that the sector plan with, you know, the environmental possible constraints, it's not a very big piece of property to be developed. So again, we can pull up the plat for Central Commerce Park, but this piece of property was not included in that plat for that.
And if I may, thank you, Caleb, for that fact check. And also too, and I know y'all know this, the Tallahassee gave us a provision, the citizens a provision for those parcels that are in the sector plan. They gave them the opportunity, they gave them the right to opt out. We have had several opt-out requests. The argument, I don't want to say argument, the issues that was raised by Ms. Rogers, those things were challenged. Our packet has been the fact of the way that our process is, the argument has been successfully, I want to say successfully, appealed to various court proceedings. So the analysis that we presented, it has been supported, carefully reviewed, and it went through court proceedings. So it has withstood all of the challenges, all of the issues that was raised. Now, we're not negating that, but the issues, the way that we proceed with this, it has been in accordance to all of the laws as given and reviewed by the administrative law judges, court cases, and court filings. So we're just proceeding, doing the same, and this property is very constrained. You see the wetlands. So it's rational planning that can avail in this issue as well.
All right, thank you, Horace. Any further questions or any discussion? And I'll accept a motion at this time if anybody's got one way or the other.
I'll motion to approve OSP 2025-01.
All right, we've got a motion for approval. Do we have a second?
Second.
All right, any further discussion? All those in favor, please signify by raising your right hand. All those opposed, motion carries. We do have one other item on the agenda today. It is a ordinance change on pari-mutuel. So I'll just go ahead and turn this over to staff if you want to run us through this, and then we'll
Chime in, you just open up and you can chime in.
knock it out.
Just to give you a recap on this issue, I don't want to go to all of the historical abuses, but just recently at a BCC meeting, there was a discussion on pari-mutuel card rooms, gaming, because this is what the request is. Currently, this issue, these type of uses, they're heavily regulated by the state, heavily, deeply, because of the nature of the uses. And so therefore, the board gave, on January the 9th, the BCC gave explicit directions to draft an ordinance, not to approve it, but to draft an ordinance to with certain conditions. Let me read it carefully. For the record, this was the motion that was made on January the 9th, 2025. Move to send this pari-mutuel card room ordinance back to the planning board to review the draft with distance restrictions to be recommended by the planning board. So this is where we are. This is a discussion item. We're gonna come back with the proper meeting so that this can proceed accordingly back to the BCC for the final review and to see what they want to do. We need to add this use to the zoning categories, and this is what staff has done with restrictions and in a certain category. And the county attorney officers here to add any insight that is necessary as we engage in this discussion for today. Thank you, board, for your time.
Chris Schaefer, attorney for Escambia County. So this is an ordinance to identify parimutuel card rooms as a permitted use of HCLI, heavy commercial light industrial zoning. It would add the permitted use under recreation and entertainment. The ordinance further defines card room, parimutuel wagering, and parimutuel facilities. These definitions align with the Florida statutes. A card room, a facility where authorized games are played for money or anything of value. Parimutuel facility and parimutuel wagering are also defined in the terms as they're used in the ordinance. And finally, there's restrictions under supplemental land use restrictions. And these provide that no state licensed parimutuel facility shall be located within 1,000 feet of a place of worship, childcare facility, K-12 educational institution, park, or playground. It also provides that if a parimutuel facility is adjacent or contiguous with an existing single-family home, duplex, triplex, quadplex, apartment, condominium, townhouse, a minimum 20-foot vegetative buffer shall be required. Additionally, an 8-foot-high wooden privacy fence shall be constructed along the shared property boundary. And I'd be happy to answer any questions you have about this, the ordinance.
Mr. Chairman.
Yes, sir.
Yeah, so it's 1,000 foot from the school. Is that 1,000 foot the path of a child can walk?
So
Or
the-
is it across the road? Because we got involved in this out there in
course.
Beulah Middle School on a situation where somebody wanted to put something
So
across
the-
the road, so that's what I'm.
Sure. The measurement is provided for, so the distance required between any of those uses shall be measured along the shortest route of ordinary pedestrian travel within public rights of way, from the main entrance of the facility to the main entrance of the place of worship, childcare facility, or park, or for an educational facility to the nearest point of the grounds in use as part of the
And
facility.
that's the problem I have overall, is they're using, if there's not a crosswalk across that road, as I understand it, they could put a liquor store right across the road or a gaming facility because it's by the path the child walks.
Can we
And
scroll
when you
down
get
to that
sta-
in this, please?
Huh?
I was asking if they could scroll down to it, so we've got it on the screen here.
Yeah,
But-
so
sorry,
that was my concern. We had that problem out there at Beulah, but we were able to get it rectified out there, but that is a shortcoming there that's in these policies.
Yeah, and I agree with you, Kevin.
Yeah. We can't get a crosswalk across the
We,
road.
yeah,
So,
we dealt with this issue when I was on the Board of Adjustment. Someone came in and wanted to sell alcohol or brew alcohol. And again, if somebody wanted to set up shop across the street from here, right, and do it, but it's
Right.
1,200 feet, the way
and
you're
I guarantee
legally
you're
supposed to
gonna
walk.
get every pastor in the county coming out and
Yeah.
all the troops, but
Is-
that loophole's in this.
Mhm.
And that's what I wanted to confirm with the attorney there, that's what
Right.
it meant. We're the child's shortest route to the school, which on 9 Mile Road, they had to walk from Beulah Middle all the way to Beulah Road,
Mm-hmm.
across and then back. And then somebody, that's where we got in discussion on
Right.
when it was proposed here at one of them, planning board meetings.
Gotcha.
So, it is a concern, and I'll talk to the superintendent and the board about it.
And I can also add that that language is added for consistency because it's used for other types of facilities. And when possible, when I draft these, I attempt to be consistent with previous language. But under the direction of the planning board, this can be amended under your direction to reflect what the board wishes it to read as.
Let me ask you a question. One, isn't there only one license given for one of these facilities in the county?
Correct. As Horace mentioned, there's a radius requirement for parimutuel gaming facilities, which effectively would limit the county to one. And there currently is a parimutuel facility in the county on the far western side. That would be the only one allowable because they have the license.
The dog track,
Formerly, I
formerly dog
suppose.
track, okay.
And my understanding is they're wanting to move locations, is that
Yes, they
correct?
wanna transfer- They, yes, they want to transfer to a different site, to a different site. And it's my understanding, and if they're here, they can respond. I don't want to speak out of turn because the issue is very complicated. But it's my understanding that there still will be only one in this county because of the distance criteria to other uses. That's my understanding. There's still, if it is allowed, there still will be only one because of the licenses and the distance and other protocols that are in place by the Florida Gaming Commission.
Horace, do you know where the intended place
I
is going to be?
don't know, maybe they do, I don't.
I mean, it's not going to be right beside a school, something.
No, so
Okay.
Meredith Bush, with Clark Partington, we do represent the entity that currently holds the license in the county. As of right now, there's no site determined. We have had several sites, however, have been unable to have county sign off on zoning verification to allow the use because this language was not in the code. So we appreciate the fact that they are putting it in as a permitted use. However, there's not a property that's been identified, so I can't tell you the proximity to the school. I would note, with this language, you know, when you talk about consistency with the code, I'm not aware of any other use that measures from a park or playground. You know, I am familiar with, from the church and school, but the park or playground language is new and different than what you typically see with the liquor sales and things like that. And so, to the extent, you know, obviously, we're gonna ask for the broadest language you will grant. You know, personally, throughout the state, these facilities have been allowed in commercial. This is heavy commercial, light industrial, so I'm gonna ask that you consider putting it in just commercial as well. But to the extent that you are taking action, we do appreciate the effort.
So that would be my only concern, that it'd be 1,000-foot as a bird flies.
So radius.
A radius.
You would do it with radii?
Yeah,
Okay.
radius,
From the property line to property line.
right.
Okay.
Instead of drawing a line a half mile down the road and then coming back and going right in front of the school.
Yeah, no, I'd
Yeah.
back Kevin on that one.
I'm
there. I think
assuming
that's
that
pretty
would
fair.
conflict with consistency. So would it be easier, instead of going 1,000 feet, you know, as you walk, go 2,500 feet, and that would kind of take that into consideration, you know, a little bit further as a radius?
I see what you're saying there, Reed, but I think for just all intents and purposes, and this is going with like cannabis sale or medical cannabis and such, you know, the state has ordinances that say specifically radii, not by the, you know, foot. We use it here as shortest route travel for that, by foot. I just think myself, radii is an easy alternative to
Yes, sir.
get to complacency here.
Sir. I agree. I'm not a voting member, but I agree.
And I will, and my deputy director, Mr. Andrew Homer, he basically is the lead with the Board of Adjustments because I think when Walker, there was some, we went to there because there was some problems with the radii, but if that's the case, the board make that recommendation, we can add it in here and let the public hearing, there still could be more discussion going. There could be, at that public hearing, we could address that further. And he has more experience in that than I do when it comes to the measurement because he's been doing that for many, many years.
And so what we've ran into with those particular cases is that we can't tell someone to jaywalk,
Right.
to cross the road in an
That's why
illegal.
we're talking about radius.
Right.
That's why we're talking about
So,
radius.
and
Yes.
that, we deal with a lot with the alcohol uses.
Yes.
And like you said, you have to go down to the crosswalk and cross there. So it comes contentious sometimes.
Do we have any other uses that are measured by radius here in the county?
That's the only one, I
think that was
believe.
the only, the
Actually,
previous.
CRAs use radii. I
Yeah,
believe.
Yeah, for
CRAs
conflicting-
use radius for a specific overlay, but I'm talking about this is general use throughout the county. This is not specific to an overlay. This is specific to a zoning classification. So we are going to be creating a rule just for this in a zoning classification. So, I mean, this, Ms. Bush is an attorney. Attorneys get paid to file lawsuits. This would open us up if we are setting this.
No.
No, it won't. And I will let counsel, but now we do have other measurements for other type of facilities. We
Okay.
definitely do have, for example, I don't want to get into those, we do have other radius for bars and for alcohol uses and for adult entertainment. Those are, so we will not be singling this use out specifically because the code does permit. We even got, if you, in certain zoning categories, 200 feet from another, so a radius and distance are throughout. This was added to be consistent with what we got for the alcohol, so it's already in place. We're just trying to be consistent, so if there's
By
a
the
change.
by the distance walking measurement.
Yes,
So,
sir.
But just think about it like this, John. It's tomato to a degree. I mean, this one here, we just make it a little bit more restrictive on the overall radii. Than, the shortest route by a foot can be gamed a little bit more. I just see this being a nicer, cleaner thing in the code that we say, hey, property line to property line radii. It just makes it easier. My personal opinion from reading it.
Well, it keeps me from having a bar trying to be put across school too, when the child has to walk all the way half mile down the road and then come back.
And it's right across the
That's a
street.
loophole that's there to bring that. But we could fight every one of them that come up, but that'd be my job if we don't get this type of support.
Horace, can you give me a little bit of history of how we have a past gaming facility on the west side of town without this? Now we're adding this is it purely because 2015, since we changed everything, that was prior?
It's my understanding that facility, I guess, I know it as the old dog track. Per se, that was here before, that was here before we really came into these rules and regulations. There was, that it could have been a grandfathered in use, is my understanding. I know it was here before I got started in 2000, so it was always here, but we never ever, it was a legal non-conforming use that could have been in existence. So that's why we're adding this, if the board so wish, to make it now as part of the Land Development Code.
My main suggestion is going with these other guys is either extend it from 1,000 feet if we have to do it by walking, or do a radii, whichever one keeps us out of legal issues. Because I don't want to create something that conflicts with everything else. But I think 1,000 feet's a little too short.
I can clarify something for you, I believe, in regards to the measurement. It really does come down to a matter of preference. It's legal to do it one way and it's legal to do the other way. You all have the discretion of how to do it. The Florida statute puts it, limits other parimutuel facilities within 100 miles. They use the radius measurement in the Florida statute. Not that that has any terrible relevance for how the county does their ordinances, but I just want to clarify that one won't keep us out of legal problems significantly more than the other, just as a point of clarification. And the code also does, I want to point out, that the code does also have similar restrictions for adult entertainment facilities or, I believe, bars as well.
Yes.
That do prohibit it within 1,000 feet from existing place of worship, childcare facility, and does include park or playground within that. And it does use the measurement as it is drafted in this draft here, but it isn't binding on how the future restrictions can be done. All this, it falls within the supplemental land use regulations, which are, by their nature, a little more one-offs than the rest of our code, but it's ultimately up to the board.
Okay. Well, we do have a speaker. I'll get there in just a second. And I guess, I'm thinking of the radius thing, which I do like, because I have had an issue with this 1,000-foot, the way you can walk. But I take, for instance, I'm looking at schools, and I look at Ferry Pass Elementary School on North Davis across from West Florida Hospital. Just south of there on Olive Road, and I'm just hypothetical here, okay, guys, just help me out. So if you had this facility on Olive Road and we were going off of the radius, right, they're going to be backdoor neighbors with Ferry Pass Elementary, which ingress egress is off of Davis. The ingress egress for this facility would be off Olive. So would that then fall into this 1,000-foot radius, even though they're really not? To me, like, I don't see the issue there, but
But the issue is where, what this does, they have, it's the closest path they can walk. When you have a state road there, where you can't get a crosswalk or anything, they can walk 3 blocks down, 1 block across the road.
well, the
and then
distance to
come
walk
back
would be
two,
well over 1,000
come
feet, but
back
I'm
two,
thinking
and
the
then put it right
1,000
there in
radius
front.
from the back of the property would certainly be within a 1,000-foot radius. You see what I'm saying?
Here's the thing, I mean, we're looking at it,
I know it's hard to-
more restrictive or more, controlling. This is for, what Kevin's bringing up here. When we do the radii from the property boundaries, it is farther, because I can say that we have 2 pieces of property next to each other. There's no street connections. I could have to walk all the way
Way around.
down, and they right next to each other. This allows for it to be purposely farther apart geographically.
Okay.
You're always gonna be that way.
As a bird
I
flies.
can't think
As
of
a
any-
bird flies.
Yeah.
Gotcha.
Yeah.
Yeah, I can't think of a circumstance where that changes, actually.
All right. Jacqueline Rogers, I'll have you come up.
Jacqueline Rogers. I have a question about when Wilson Robertson opted out of his property and wanted to make it HCLI, he couldn't do it because it was mixed-use suburban. So the county allowed HCLI in mixed-use suburban, where it was never allowed before. But they said you just can't do industrial if HCLI is in mixed-use suburban. So I guess my concern is, you're saying if it's an HCLI, it'll be allowed. Well, that might not be appropriate in mixed-use suburban. HCLI is also available in mixed-use urban and other land uses. So I'm not saying you can't have it at all, but do you think it's appropriate to have parimutuel facilities in mixed-use suburban areas? And that might be a limitation that needs to be added to this ordinance. When we went to DEO, I contested the industrial, and it was not listed as a range of allowable uses. And I don't see that it would be here, but I don't know what parimutuel is considered. If that's just retail sales and services, I'm not sure. But that's something to consider. Do you want in mixed-use suburban areas where you just saw how rural it was up there, you saw all the homes up there, there are HCLI lots there, even though they're single-family homes, you're going to allow a parimutuel facility up there amongst that area? So just something to consider. Thank you.
All right. Any more discussion? And Horst, I just want to clarify, the action of the BCC was for us to discuss and give a recommendation on just the distance?
The ordinance itself with the zoning category with heavy commercial, light industrial, along with these restrictions. Yes.
Gotcha.
Because again, we gotta have a public meeting, and we gotta come back before go for the board.
I make a motion to move forward with the language that's currently.
The draft language as written.
All right, we've got a motion on the table to move forward with the language as written. Do we have a second? All right, if there's no second, then motion fails for lack of second.
I'll go ahead and make a motion that we take this forward with a radii restriction,
Of,
1,000 foot.
1,000
from-
foot.
Yeah, we just use radii versus walking distance. That way the state likes to use that more in their ordinances for this very reason, because there's less interpretation on how you get to that. It's property boundary to property boundary on the shortest, corners.
Do we have to articulate that exact language in this motion, or can we task staff to rewrite?
With that type of change, it is small enough where I could do the rewrite of that measurement calculation according to the direction of the board and present that version with my legal sign-off to the Board of County Commissioners for their approval or denial.
Yeah, it gotta come
Come
back.
back here, excuse me, before that.
But
So we
yes.
would have to see the exact language
Yes,
again and vote
absolutely.
on
Yes.
it.
Yes.
So this motion is another 30-day delay.
No, we could, well, when it's coming back before the,
This is only a discussion item, so
Oh,
we're not
okay.
voting it to
Oh.
go to the BCC anyway.
I got you.
Yeah.
but I do want to be clear, I do want to be clear on the schedule, We still want to have the public hearing on when the public hearing on this. before the-
This is coming back to the planning board on March 4th.
Right, so we do want to keep that timeline.
Then it's going to go to the BCC for its first hearing on March 6th.
So if it's a discussion item, is it really a motion, or can we just say here, please rewrite and bring back to us for a vote?
I think a motion for direction of, the
Yes, a
direction of the
motion
board
for
would be
direction
good.
is in-
Yeah.
Okay.
Yes, sir.
So, your motion was to have another draft ordinance brought to us using radii instead of,
versus, yeah, the language we have here along the shortest
for
route
us
of
to
linear
review at the
pedestrian
next
travel.
meeting. All right. Do we have a second on that motion?
Second.
Second, any further discussion? All those in favor, please signify by raising your right hand. All those against? All right,
Thank
perfect.
you.
So we'll review that next month and keep on chugging along. I didn't have anybody signed up for public forum. Is there any further information we need from staff?
Can I just ask for a clarification, just out of pure personal interest? With parimutuel, it's a Florida, state-regulated, and with the statute of the distances where only one can be in Escambia County, that distance does not apply to other states then, because it's just Florida?
I would leave that up to the legal.
Because if there's a distance in Baldwin County,
I can look into that issue. This is the discussion item, so I could address that question at the following meeting.
I would suppose it stops at the state's jurisdiction.
Correct.
Yeah, yeah.
All right.
I want,
Yep.
just a question for staff. Talk to us about, because it's not on the calendar, when is, the 2411 going to come back to us again for the third time?
When we have more information from the applicant and the client, if there would definitely be another public meeting, everything would be notified. So I just don't want to give you a certain date, but it got to come back from this board as recommended and direction given from the BCC. So it's definitely coming back before this board. Don't know when yet.
All right. Thank you. If there's nothing else, we stand adjourned.